Okay, good afternoon, everybody. Good afternoon and welcome. We're just waiting for the numbers to rise, waiting for people to dial in. Okay, the numbers are going up. Very nice to have you with us today as well. And I'm sure everyone's absolutely desperate to get to the next layer or the next tier of getting out of lockdown or opening up or whatever it's called, and which is happening on Monday, I understand. Yeah, really keen, and the rest of the team as well, to get to that next stage. Okay, the numbers are going up, which is really good news. We're just going to give it a couple more seconds and then we shall begin. Okay, it looks like we're stabilizing. We shall start. And first of all, a very large, very big welcome from all of us here at Jones Chase. Welcome to our employment webinar, and I'd just like to thank all of you for your continued support with this project. For those of you that are new to our webinars, we are of course a firm of specialist employment lawyers. We act for a number of companies from PLCs all the way through to startups, and also for some fantastic individuals as well. And we have a very high success rate of looking after those that we represent, which is north of 95%. And once again, we are delighted to have you with us. So we have, as ever, plenty of content to get through today. But for those of you that are new to the webinar, and there are some new people with us today, I'd just like to quickly introduce the team who are itching to get going and also itching to get out of lockdown. Going anti-clockwise on my screen, we've got one of the firm's partners, Susanna.
Hello.
And the other partner of the firm, we've got Shona.
Hello, good afternoon.
And Shona's actually got a surprise topic for you all, by the way. So it wasn't on the email that went out. So Shona's going to speak to everyone at the end of the webinar about vicarious liability, based on the discussion we had earlier this week. So that's the fourth topic for today, just to let you know. And we've also got Harriet, one of the firm's senior associates.
Hi, everybody.
And Catherine, one of the firm's trainee solicitors, soon to be qualified solicitors.
Hello, everyone.
Okay, thanks, team. That's great. In terms of the format for the webinar, we will run through some legal updates today. And if you want to ask questions, please do. And we do want to make this as interactive as possible. And where possible, do use the Q&A box. You can hit the anonymous button if you want to ask questions on an anonymous basis. If you don't mind your name being displayed, then you can use the chat function as well. And just as a quick reminder, if you don't hit the anonymous button on the Q&A box, then your name will be shown to everybody. If you do want to speak live, please let either me or the rest of the team know using the chat or Q&A box and ask to be unmuted. And then either myself or one of the team will go on and meet you. I should add that we are recording the webinar to allow us to distribute this to a wider audience. So please bear this in mind, particularly if you want to ask questions on an anonymous basis. Very importantly, I must emphasize that the points that we're covering today do not constitute legal advice. So much depends on the facts of the case, and sometimes the approach that you take in one case is not the approach that you will take in another. So therefore, please do not rely upon what we say today as being formal legal advice. If you want anything checked or you do want to steer on something, definitely get in touch with us. We'll be more than happy to help you. As a quick reminder, the information that we're covering today is accurate as at 4 o'clock on the 8th of April 2021. Things are changing very quickly, so again, do drop us a line if you have any questions. And we do appreciate that everyone's time is precious, so we'll be finishing at 5 p.m. today on the dot, if not before. And just lastly for me, we do helping people, so if you have anyone or any companies or family, friends or other contacts that you have who may need some employment legal advice, definitely feel free to pass our details on. And also, if you know of anybody that would be interested in joining our mailing list for invites to these free webinars and also a series of bulletins that we will be releasing, definitely drop me a line, dean.jones@joneschase.com, and we'd be happy to add you to the mailing list. Okay, oh, and yes, so we do act for individuals as well, so not just companies, as a quick reminder. Okay, so moving very quickly on with the content. I've done this in 4 minutes today. I'm very proud of myself. And first of all, we've got Katie, who's going to speak to you about some of the new legislative changes that have taken place this week. So over to you, Katie.
Hello, everyone. I'm going to go through a couple of changes that have come in this month in the last week. So there's been some changes to the minimum wage. So the national living wage, which has been the highest band of the national minimum wage, has increased to £8.91 per hour as of the 1st of April. In addition, the age threshold for the national living wage is amended so that it applies to 23 and 24-year-old workers from the 1st of April. Previously, the national living wage was available to only those 25 and over. Other national minimum wage rates also increased on the 1st of April, with hourly rates rising to £8.36 for workers aged 21 and 22, and to £6.56 for workers aged 18 to 20, and £4.62 for workers aged 16 and 17. There's also been changes to statutory redundancy calculations. The new limits on employment statutory redundancy came into force on the 6th of April. Employers that dismiss employees for redundancy must pay those with 2 years service and amounts based on employees' weekly pay, length of service and age. The weekly pay is subject to a maximum amount. This has changed to £544 from the 6th of April. You should ensure that calculations for statutory redundancy payments are made on the basis of this maximum amount for redundancy dismissals on or after the 6th of April. There's also been changes to statutory maternity, paternity, adoption, shared parental and parental bereavement pay. The weekly rate for these payments have increased to £151.97. This is from the 4th of April. There's also been changes to statutory sick pay. This has increased to £96.35 from the 6th of April. It is up to you to make sure that staff on maternity leave, paternity leave, adoption leave, shared parental leave, parental bereavement leave and sick leave are paid these statutory minimum rates. You should also review your policies and documents that may mention these rates, such as your family leave policies or your sickness absence procedures, and make any necessary changes. We ordinarily wouldn't advise putting in rates into your policies, but you might have already got these included. One thing to note for some of you is that you should be thinking about your reporting your gender pay gap. This only applies to employers with 250 or more employees, and you're normally required to publish your gender pay gap report by April. The deadline for private sector and voluntary sector employers is normally the 4th of April. For public sector employers, it's the 30th of March. However, the Equality and Human Rights Commission has stated that due to the coronavirus pandemic, enforcement of the gender pay gap reporting duty for the 2020-2021 reporting year has been delayed 6 months and does not begin until the 5th of October 2021. You are still required to do it, you just have an extra 6 months, but you are encouraged where possible to do this before October. Just a quick update for those, I'm not sure how many of you this will apply to, but the government introduced an incentive payment for employers hiring trainees or apprentices through the apprenticeship service. This was only for apprentices hired from the 1st of August 2020 to the 31st of March 2021. The deadline to make this application is the 30th of April. So for any of you who did employ an apprentice with the right age group and satisfying criteria, need to apply by the 30th of April. There's also been changes to the post-employment notice pay calculation. Post-employment notice pay is part of a termination payment, which is treated as being payment in respect of an employee's notice period and subject to income tax and employers' national insurance contributions. The government has amended its legislation to include an alternative calculation for post-employment notice pay to be used for an employee whose pay period is defined in months, but their contractual notice or post-employment notice period is not a whole number of months. I'm sure many of you already know this, but it's a complicated formula and it's a bit too complex to cover in any more detail on this webinar. But if anyone does need guidance on post-employment notice pay formula for exiting employees, please do get in touch. And finally, the vento bans in discrimination cases are changing. So the presidents of the employment tribunals in England and Wales and in Scotland have issued a 4th addendum to the presidential guidance for an employment tribunal awards for injury to feelings. So for those of you who don't know, injury to feelings are awards given to individuals who bring successful discrimination claims in the employment tribunal. At present, they are subject to a maximum and are categorised into 3 bandings depending on the severity of the treatment. These bandings are called the vento guidelines. These vento bans for such awards have now been increased. For claims presented on or after the 6th of April 2021, the bans are as follows: a lower band of £900 to £9,100 for less serious cases, a middle band of £9,100 to £27,400 for cases that do not merit an award in the upper band, and an upper band of £27,400 to £45,600 for the most serious cases, and it will be in the most exceptional cases that are capable of exceeding £45,600. So that's it from me on the quick update of the April change.
That's great, Katie. Thanks a lot. I think it also says a lot about how long you've been in the legal or HR career, because you can remember the vento bands, and now I think the top of the middle band used to be the top of the upper band when I began doing employment law. So everything's moving on, and that was great. And it's also very interesting why I personally don't know why the government delayed the reporting of the gender pay gap information. Interesting, but a couple of weeks ago we had a webinar about for International Women's Day promoting equality. So it is a little bit of a shame to see that, but hopefully as you say, Katie, people still have to do it, and they have to get on top of it. And it has had a positive impact since they've introduced gender pay gap reporting. So long may that continue. Okay, next topic we got can be introduced with just 2 letters and 2 numbers, IR35. Over to you, Harriet.
Thanks very much, Dean. So yeah, we're going to have a few slides to help try and explain what can get a bit of a tricky topic. I don't know if you want to get those ready, Dean, for when I get stuck in. So as Dean mentioned, IR35, I'm going to talk about the new off-payroll working rules in the private sector, which came in on Tuesday, on the 6th of April, so another change this week. They were put back from April 2020 due to the pandemic, but have now come in. We did cover these rules briefly at the end of last year, but given they've just come into force and we've had quite a few inquiries from clients in the last few weeks about the impact of these rules, so we thought we'd just give you a recap and have another look at them. So you need to know about these rules generally if either you as an organisation engage contractors via their own personal service company, so via an intermediary. So rather than contracting with the individual directly, there's their own personal service company in the middle. And your organisation is a medium or large organisation, and I'll explain what that means shortly. Or, and this is a thing we've seen quite recently, is if your organisation itself is not a medium or large organisation, but you do engage contractors via personal service companies, and then you supply their services on to a medium or large end user client. So you're the supplier of services, which is quite common. And it's this latter scenario which has been causing some issues for our clients recently, as many of these sort of large end user clients are deciding that they don't want to have to deal with IR35 at all, and are looking to place a blanket ban on their suppliers providing workers who operate via their own personal service companies, and are insisting that any individuals who are providing services to them have a PAYE contract with the supplier. So I'll come back to that, but just to run through the rules, just to make sure that everybody understands them, and obviously forgive me if you're already very familiar with them, but not everybody might be. So IR35 itself has been around for about 20 years, so that is not a new concept, and it was introduced to prevent tax avoidance and to ensure that someone who's working like an employee but through an intermediary, typically their own personal service company, pays tax like any other employees. And originally it was the individual contractors who were essentially responsible for making their own employment status assessments to HMRC. So you can imagine how many people didn't do that properly. So in 2017, there were IR35 reforms in the public sector, which shift the responsibility for carrying out these tax assessments from the individual contractor to the public sector client. This was so successful, increasing HMRC revenue by an estimated £250 million in the first 12 months, that the government thought that they'd extend that beyond the public sector. So finally now in 2021, we have this extension to the rules to private sector organisations. So now it's the private sector kind of end user client who's going to be responsible for determining the contractor's tax status, and therefore that burden has been shifted from the personal service company to the end user client. And obviously this is going to have some big implications for business and contractors, particularly because, as I said, it's the end user clients of services who are now burdened with having to look at this tax status, which, you know, generally they probably would rather not bother with. And there's huge, you know, reputational and financial risks for businesses in getting it wrong, and there's sort of large penalties and interest from HMRC that will apply, although apparently HMRC have said they're not going to apply penalties in the first year, which is kind of them. And they're going to focus on helping businesses to comply with the rules. So Dean, if I could have the next slide, please. So just to confirm that these reforms, they apply to large and medium-sized businesses in terms of being the business that engages that contractor via a personal service company. So if you're a small company, you're going to be exempt from that part of the regulations. And on the slide, I've just set out what that means. You have to satisfy at least 2 of these criteria. So annual turnover of under 10.2 million, balance sheet total of under 5.1 million, and 50 or under employees. So if you satisfy 2 of those, you are not caught by the rules in terms of being a client who has to do the status determination. So your current situation remains in place, The intermediaries, the personal service companies who you engage with, will have the responsibility for assessing their tax, so no changes. The rules also don't apply to wholly overseas clients or to clients who have a fully outsourced service, as opposed to getting individuals to provide sort of personal service. And just a reminder, the rules don't apply to contractors who are engaged directly with you, so where there's no personal service company, or anyone who's already subject to a PAYE and NIC deduction, so agency workers or those who provide services through a traditional umbrella company arrangement. And at the end, I'll come back to what might some possible solutions be, but those types of arrangement may be things that you want to consider, because they aren't going to be caught by the rules directly. Yes, Dean, if we would have that next slide, that would be great. So what are the obligations? Just to take you through, you can see on this slide, there's two different scenarios. The three-party chain, which is the one that's reasonably straightforward. So you have your individual worker, they have their own personal service company, which is the intermediary, and they provide their services to an end user client. And in that scenario, under the legislation, that's the client and the fee payer. I'll come back to what those mean. And then you've got your four-party chain, where you can see you've got an agency stuck between the intermediary and the client. And that's what I refer to as a supplier. So that could be somebody, for example, you might have an IT company who engages contractors via their own personal service companies and then passes on those workers to large organizations, large banks, etc., for that IT support. So that kind of scenario would be caught, because your end user client there is likely to be a medium or large organization. So where this applies, it's this end user client who's got to decide the employment status for tax for each contractor on each engagement that's undertaken by them, and they have to use reasonable care in reaching that determination, which I'll come back to. So once they've made their status determination, they've got to inform the individual and the party it's contracted within the supply chain. So they've got to pass that determination back down the supply chain until you reach the fee payer. So in my four-party chain, you can see it would be the client who has to pass that determination to the worker and back to the agency or supplier, who is the entity that has to pay the intermediary. And they're called the deemed employer. So if the contractor is inside IR35, then it's the fee payer or the agency which has to then deduct PAYE. And that's where your sort of small supplier company could get embroiled in this, because they may not be caught as a medium or large size employer in terms of being the client, but if they are the fee payer, they do have to sort out the PAYE. So it's capturing more organisations than just the large ones. And if the fee payer, so the sort of agency supplier in that scenario, doesn't pay the tax correctly, the responsibility gets passed back up the chain, ultimately to the client. And obviously, if you're a very large organisation using lots of contractors, who you may engage them through suppliers, obviously that's going to cause you concern if those lower down the chain don't do what they're supposed to do. And that's why quite a lot of our clients are being asked for indemnities with these large organisations to ensure that they've protected their position if the sort of agency fee payer doesn't do what they're supposed to do with tax. And some of the large companies are also requiring that services are provided through umbrella companies, or they are insisting that the individual workers actually become employees. So that sort of agency organisation in the middle would have to operate PAYE. Now, this is proving a problem, because obviously this is detrimental financially to the contractors, because they're going to get less money overall due to the tax and the NICs that will be deducted. So really, it becomes a reputational issue as to whether or not the organisation who's insisting on this is going to end up getting the best talent if they're insisting that people have to go through PAYE. The difficulty is that there may not be much option here. Ultimately, if people want to do the work for the large organisations, they're going to have to find a way to provide their services in a different way. So how do you do this status determination? So just briefly, because some organisations, those of you on the call may work for large organisations who are going to need to do this status determination yourselves. So Dean, if I could just have the next slide, please. The important thing is that you need to consider both the written contract and the actual practical day-to-day arrangements. And we quite often will see a scenario where the contract says one thing in terms of how this contractual arrangement works, but the reality is actually quite different. And HMRC are interested in both what the contract says and the practical reality of the arrangement. And when this sort of status determination is carried out, you use the main factors that you do when you're looking for employment law purposes broadly as to whether somebody's an employee or a worker or self-employed. Actually, I think there might just be, is it the slide before, Dean? I don't know if we've gone on. Actually, maybe go one more slide. Sorry, we've got, that's it. Yeah, I'll have to go back. Sorry, they're in the wrong order. So we've got mutuality of obligation, control, and the extent of personal service, and whether there's a right of substitution. So we look at those kind of classic employment status factors. And to make things a bit easier for the clients, there is an online tool which you may be aware of called Check Employment Status for Tax. It's called CEST test. And HMRC is encouraging people to use this. It will ask a series of questions. You have to input the details in very accurately and honestly as to how that contractor relationship works. And if you do it properly with reasonable care, then HMRC will stand by the outcome of that. But it's an ongoing process. Obviously, every time you engage a new contractor or the working relationship changes, that test will need to be. If we could just pop back a slide, sorry, just to, I think actually the previous slide was, yeah, that was just showing where the obligations lie, just to set it out so you can see the difference between the obligations on the client and the fee payer themselves. So just moving on to the sort of final practical points in terms of what should you be doing. Many of you will already have done this if you have contractors, but obviously to make sure you carry out a full audit of your existing contractor workforce to identify who may be subject to a status determination under the new rules. And obviously if your organisation's caught in terms of being medium or large, it's your organisation who's going to have to do the status determination tests. And as part of this process, you can look at whether your contracts actually reflect how the contractors are operating in practice. So there's quite a lot of due diligence that might need to be done. If you're going to need to do this test, use the government's CEST tool and make sure that you use reasonable care. And this is referred to a lot in HMRC's guidance. And really a few key points on that. It means don't make blanket determinations. So you can't just say we're going to treat everybody in the same way. Every engagement might be slightly different. So you have to do it on an individual basis and make sure that your information is accurate. So you may have to speak to the contractor, speak to the managers on the ground in terms of how the relationship actually works. And obviously you need to have somebody internally who's going to deal with the status determinations. What's that process going to be? Does this person need training and support? So it's making sure you've got your own internal process there, because if you don't take reasonable care, what this means is that if you have that kind of four-party chain, it's the client at the end who's going to be responsible for the employment taxes, even if they're not actually the fee payer. So there's somebody in the chain below who's actually going to be paying the intermediary. You can inadvertently become liable for that tax if you don't do this properly. As I said, you need an ongoing review there. This is not just to do it in April 2021 and that's it. It's an ongoing obligation. And I think really importantly for right now, opening dialogue with contractors who've been identified as having employee status for tax purposes. So if you engage people who actually fall foul of this now, so they've got deemed employment status, you're going to have to look at other ways in which you can engage them. So is the reality that they are working like an employee? Do you need to take them on as an employee? Or do you need a sort of fixed term contract if it's just a short term assignment, or a casual worker contract, which we don't usually like, but trying to be creative, that could work. Should they be engaged via an umbrella company? Or you may want to engage them as an individual contractor, so taking out their personal service company. And I think if you're in a situation where you are more the supplier stuck in the middle and you are having a large organisation put obligations on you to say, actually, we don't want any intermediaries involved, you've got to get rid of all your contractors' personal service companies, then again, you need to engage with your contractor as to, okay, what are we going to do going forward? Are you willing to still do the work, engage on a PAYE contract? And that's obviously a commercial discussion that you need to be having. And my last point is just to keep detailed records of everything that you do in terms of your decisions and your processes, because if HMRC come calling, they'll be looking for the evidence that you've used when making these status determinations to decide whether or not reasonable care has or hasn't been taken. And that is all I wanted to say. That's the end of my bit.
Okay, that's great. Thanks very much for making a very difficult topic very easy to understand, Harry. That's great. Thank you. And I think that's great. And as a firm, the experience we've had of dealing with it is typically those not gigantic companies, but it's the intermediary companies who are sending consultants or contractors to work for larger organizations who've being completely caught in the middle here, and the large organisations have just said, we're not taking, in some cases, not naming any names, but we are not having any contractors anymore with personal service companies. So that's it, it's not a problem, because they just simply don't want to be responsible for running the assess test, as you say. And I guess one of the other, it's definitely worth all organisations looking at who works for you on your supply chain as well, to make sure that there's no problems here. And because even if HMRC are going to be lenient in terms of penalties and penalties being applied for non-compliance with the law here, there's still an inherent tax liability that's potentially building up from the 6th of April 2021. The quicker that people get on top of this, absolutely the better, I think. And just finally, as you've said, there are some creative ways around getting the work done and making sure that there are people still around to do it without upsetting people. A number of different options to engage your workforce in different ways, whether you're an end user or an intermediary or even a contractor. And if anybody needs a hand with that, definitely drop us a line. We'd be more than happy to help you. So moving quickly on and to our third topic, and Susanna, you can speak to everybody about the employment. Sorry, I'm messing my words up. Employment Tribunal Statistics. I never like that word statistics, by the way, but I've said it twice now. And also the sort of current trends in case law. So over to you, Susanna.
Great, thanks. So I actually love statistics, although I'm not very good at maths, but I do like them. And I might be a bit nerdy like this, I don't know if my colleagues do it, but I do always look at the Employment Tribunal Quarterly Statistics, mainly just to see whether I think there are any trends building. And I thought it might be useful as we're into the first quarter of 2021 to look back at what impact the pandemic had on the level of employment tribunal claims. And not surprisingly, there has been a very significant increase in employment tribunal claims, which probably does correspond quite naturally with the pandemic and what we know has happened, which is that there have been some quite a lot of people who've lost their jobs along the way as a result of the pandemic. In relation to individual claims, so that's just an individual bringing claim for unfair dismissal or unlawful deduction of wages, there has been in the last quarter a 25% increase in claims, but absolutely staggering and probably quite alarming, an 82% increase in multiple cases. And when we're talking about multiple cases, this is claimants bringing claims together arising out of the same set of facts. And those type of claims appear to have arisen as a result of employers seeking to introduce what might be deemed less favourable or certainly not liked changes to terms and conditions of employment, and also to where they've had large redundancy exercises. And I suspect in a number of those cases they're union backed and the union are pushing that forward. So that is something that we anticipate as the furlough scheme is brought to an end later on this year, that you may continue to see this ongoing increase in multiple claims. And I think just as a word of caution to any of our clients who are thinking of doing collective redundancy exercises, it again just indicates how important it is to get this right and to ensure that you are following the proper collective consultation process. Most surprising to me was looking at what type of claims there were generally. And unfortunately, because the tribunals are so backlogged, in fact, there are 44,000 cases in the last quarter that are still waiting to be processed and have not actually been given codes in relation to what the claims are about. What is indicative so far is that the largest rising claims that are coming through are actually age discrimination claims. So this time last year, so between October, December in 2019, there were 582 age discrimination claims issued. In the same period in 2020, that has risen to 1,608. And the increase is probably down to the fact that it's both end spectrums, it's young people and probably people over 50. The young people, I think there's been quite a lot in the press that we've seen that young people have been specifically targeted and made redundant or furloughed. And certainly it appears that older group of 50 and over are getting disproportionately affected in redundancy selection. Certainly something to be watching out for in respect of any process where you are looking at terminating. And as Katie mentioned, if you look at the Vento guidelines, those have gone up again. And the middle banding, which in my experience is where injury to feeling gets awarded in discrimination claims, is getting uncomfortably high at the higher end of that banding, and makes claims for discrimination again just a little bit less palatable for anyone to want to deal. And then we get some perspective, because I think you think, oh my God, so many claims. And certainly our experience at Jones Chase is we have seen an increase in the number of tribunal claims that we're dealing with, is to look at what happens with the claims that have been dealt with. And what is the outcomes in the tribunal. In this last quarter that we've had, 27% of cases were resolved through ACAS, 22% were dismissed upon withdrawal, and 20% were withdrawn. Now, taking that 22% and the 20% on withdrawal, that might well be also because those cases were settled. So again, what we're seeing is a trend of high settlements. 9% of the cases that have been dealt with in the last quarter were struck out without a hearing. But interestingly, only 7% of cases were successful at hearing. And for me, that is again, and I'm not just plugging employment lawyers and why you should use them, but it just demonstrates to me that if you are defending cases that are being brought against you, these are complex issues that have to be dealt with. And whilst the employment tribunals were originally set up so that individuals within companies and themselves could bring their claims without needing to have legal advice, actually employment law is becoming more and more onerous for everybody. And I think that what those statistics show is that if you are defending those cases that are defended all the way through, the percentage is so low that I think it's because people are really fighting those claims well and arguing those cases very well. But what we do see from that what I've just talked about is that actually a very significant majority of cases are actually being settled. The backlog, and there is an enormous backlog currently in the employment tribunals, has been caused in principle because of the increase in numbers, but also because of the fact that the employment tribunals were just simply unable to cope with the COVID-19 restrictions. So their case management system that they had in place was not able, you weren't able to use it. It wasn't workable from a remote working. And so when I look at what things are going to happen in the tribunals next, one of the things that the tribunal has introduced is a new case management system, which is going to be rolled out by the end of May. And this is a system that works well, apparently, and also provides for it to be administered remotely so that the admin team that sit behind the judges are going to be able to work from home. There's obviously been a significant increase in the remote hearings, and this has thankfully to a certain extent helped them catch up with some of the backlog. And so it's anticipated that in 2021 we will revert gradually back to pre-COVID levels where things will be dealt with much quicker. Of the cases that haven't yet been processed in terms of given their categorization, it is anticipated when we look at the next quarter's statistics that a significant majority of those cases are expected to be relating to whistleblowing and health and safety, as well as the usual unfair dismissal type of claims. What we know from the statistics, though, is that the employment tribunal system is absolutely struggling to cope, and that we are likely to see this increase, an ongoing increase in multiple claims being brought. So I just repeat that where you're looking at making, and I know that some employers will be thinking about making some major changes to terms and conditions of employment that will affect all their employees, you need to really be having proper consultation with your staff for the appropriate lengths of time in relation to that. What does that mean for us in terms of the employment tribunal going forward? And rather helpfully, last week we got issued with an updated employment tribunal roadmap, which gives us an idea of how the tribunals are going to operate and deal with cases for 2021-2022. I think the general view is that face-to-face tribunals, so in-person tribunals, really is the most desirable way of dealing with matters. But realistically, what has certainly come out of 2020 and the virtual video hearings that we have had is that what that means is the tribunal has literally been able to triple its ability to hear cases. And so what we're going to see going forward is we're going to have this remote, hybrid, and also in person. So a bit like reflecting how we're going to be working really going forward, which is interesting. As I said, they're introducing this new case management software, which fingers crossed will work much better. They're also introducing an official virtual region. So we currently have 10 regions across the country, so 10 employment tribunal regions, but we're now going to have a virtual region that will sit alongside that, and that virtual region will be made up of 100 fee and salary paid judges who will deal with remote hearing. And actually one of the positives I've experienced in some of the virtual hearings I've had in 2020 was that we had judges from Scotland dealing with a matter. We had a judge based in Manchester, and we had lay members being pulled in from all over the country. And I think that worked really well. So that's going to be put in place. They're also, I don't know whether they're going to really call them, whether these are super legal officers, but they're creating this legal officer role. They're currently getting mid-April 16 of these legal officers up and running, and they will have delegated powers. So those will be delegated powers from judges to deal with certain matters, mainly administrative, with a view to pushing cases forward. And that can only be a positive thing, instead of every application, every request having to be submitted before a judge, which does delay things. And then we've got a clear guidance as to what will happen with certain types of hearings, certainly for the next 2 years. All preliminary hearings that must be held in private will be dealt with either by phone or video. Other preliminary hearings in public, or where there is an application for strikeout, will be dealt with by video hearing. Judicial mediation, which has become quite popular in 2020, will be dealt with either by telephone or again by video. And final hearings for what we would call the more basic claims, such as unpaid wages claims, unpaid notice, holiday, that type of thing, redundancy payments, those will all be dealt by virtual hearings. And then final hearings for others, such as unfair dismissal, whistleblowing and discrimination. The trend will be that gradually we will move back with the aim to having in-person hearings. But in general, at case management hearings, at the preliminary hearing, the parties will be asked whether they would be willing or would like to have hearings dealt with by virtual hearing. And if parties are in agreement with that, will be the way forward. And I suspect, given that it's probably likely virtual hearings will get listed faster, that might be a route that we now very seriously consider for certain types of cases. I don't know what my colleagues' views are. My experience so far was that although I think virtual hearings work, I'm not sure that justice is really felt to be given from a computer online. But it's interesting to see how we're adapting, and that is probably going to become the norm going forward. So that's my highlights on that.
That's great. Thanks, Suzanne. I think loads of things to mention on that, but I'll keep it brief. But I think with the incredible delay that people are now going to be suffering, all claimants typically want the hearing to go ahead as quickly as possible so they can get their hands on a judgment if they're seeking justice or otherwise compensation. And typically employers are generally employers are more keen for hearings to be delayed into the future and to make the case more difficult for the claimant. So at the moment it's swinging into the employer's hands. And from what you said with virtual hearings as well, when acting for companies, the amount of times I've applied for a postponement of a hearing or for it not to be listed in a certain date because, for example, the chief executive has gotten the pre-existing holiday planned over the summer, and then he provided that they booked the flights in time. So multiple postponement requests were made on behalf of people's travel plans, I guess, if the hearing's now virtual. that's probably not going to work anymore. I don't know.
Yeah. And you'll have the hybrid. So you'll also have the hybrid version, which is where you may also have evidence being given remotely or certain aspects being dealt with remotely, even though most of the parties are in hearings. And that's taking place now already.
Yeah, and I think some companies could use the delay in the system to try and provoke settlement from claimants as well, just by giving them a more immediate resolution, because as you say, the delay is incredible. And yeah, thank you very much for running through all of that. Does anybody else have anything to say before we move on?
Yeah, just one thing. When somebody can bring a discrimination claim or a whistleblowing claim, they can do so and remain in employment. And if you've got a hearing 2 years hence, that makes that employment relationship extremely during that period of time. And I wondered if there was any mention of expediting cases. I know there are, in certain circumstances, they will expedite cases, but this doesn't seem to be one of them. And just
no, I think the only cases that are continue to be expedited, Shona, are going to be the money cases. Yeah. So the unlawful deduction of wages, that, and we saw that happening in 2020.
Anyway.
Yeah, so we saw that I think I had 3 cases that were redundancy based, and those got progressed very rapidly, which was surprising.
Yeah, so, and I think it's an oversight on the tribunals not to recognise that very difficult employment relationship and limits claims being brought by individuals if they think they have to remain in employment whilst they bring that claim. So, yeah. It's just a point.
Yeah, it never used to be like this. I think there's a lack of funding of late from the government as well. But anyway, I guess moving on, and Susanna, thanks very much for that. That was great. We've had 2 questions in, and one from Karen in the chat box. Hi, Karen, and one in the Q&A box. Harriet, both questions are on. I could probably deal with the one in the Q&A box from the anonymous attendee, but could you have a quick look at the one from Karen, and then we'll get back to it after showing a section, if that's okay?
Okay.
Great, thanks. Okay, Shona, over to you for the final and surprise section on vicarious liability. So over to you, Shona.
Yeah, this has been built up as a surprise, and I hope you like surprises, because it's a bit of law. Vicarious liability is where someone becomes liable for the acts of another. So in the employment context, that is, the employer becomes liable potentially for the acts of the employee. And it's just determining when that can be. And I suppose one of the reasons why it's being covered now and why it's being asked about by clients is due to home working and possibly the occasions in which someone, an employee, can create a liability for the employer could be increased, bearing in mind there isn't that over-the-shoulder monitoring that can be done ad hoc whilst you're sitting in the office. The way to illustrate vicarious liability, there are 2 main rules. One is that there has to be a relationship between the person who's done the wrongdoing and the person who is ultimately liable. And the relationship that we'd talk about here is the employment relationship, or a worker relationship, or even a service provider relationship. Then once you've established that relationship, you then have to have the notion of, was there a sufficient connection between what the wrongdoing is alleged to be and what the individual was meant to be doing. So a sufficient connection between the employee's job and their duties and the wrongdoing that is alleged to have committed to then make that employer liable. So having those 2 tests, the relationship test and then a sufficient connection. And there are 2 cases that illustrate this quite nicely, and both involve Morrison's and both involve a USB stick. So the first case is Morrison's, the store area where there's a store affiliated with a petrol station, and an employee worked at that petrol station. He was an employee of Morrison's, and he worked inside the petrol station, but he also went out and about around the petrol pump. And one day, a potential customer was travelling from Birmingham to London, stopped off at this petrol station, and he had a USB stick that he wanted some papers printed for his meeting in London. So went into the Morrison shop to get these papers printed from the USB stick. And for some reason, the Morrison's employee started shouting quite foul language and racist language at the customer to say that they couldn't print from that USB stick. That was the summary of what was said, but using foul and racist language. The customer then leaves the petrol station, goes towards his car, which he had parked at a petrol pump. The Morrisons employee follows him out, carries on shouting foul and racist language, opens the car door in which the customer is sitting and starts shouting it in their face. Shuts the door, and that's the end of that altercation, but not the end of the matter, because the customer naturally contacts Morrisons to say, this is outrageous, I have been extremely disturbed by what's happened, it was racist, it was foul, please can you do something about this because I'm holding you liable, and brought a claim because of the psychiatric damage as a result of the altercations. Now, was Morrisons liable for that altercation? Now, naturally, in the employee's terms and conditions, part of his duties is not to swear and be foul-mouthed at customers. So the argument could be that, yes, there is a relationship. The relationship is employer-employee. But no, there isn't a sufficient connection between what this employee is meant to be doing and what he actually did. And this case went all the way up to the Supreme Court, and the Supreme Court said, yes, there was a sufficient connection, and therefore Morrisons is liable for the act of its employee to that particular customer. And the reason for the sufficient connection was the employee had the ability to work in the store. That was his job, to answer questions about printing and USB sticks and selling goods. And it was also his duty to be on the forecourt at the petrol pump and to interact with customers. And the employee did this, and in doing so was racist and foul-mouthed. So Morrisons were liable. So that's the first Morrisons case in a USB stick where they were found to be liable for the wrongful act. Then the second case with Morrisons and a USB stick is where a very senior employee, this time based in head office in Morrisons, not in a store. I'm not trying to put you off Morrisons because other supermarkets are available, but they just highlight this rule very well. Senior IT employee, he has responsibility for payroll information. He's disgruntled for various reasons about his pay within Morrisons. He takes a USB stick and he takes from Morrisons payroll information 5,000 employees and ex-employees' names, addresses, bank details, and decides to make that public knowledge. And again, this case went all the way to the Supreme Court to decide if Morrisons was liable for that data breach and therefore owed damages to the 5,000 employees and ex-employees whose data had been provided out into the public despite having to be protected by Morrisons. And in that case, the Supreme Court decided that there wasn't a sufficient connection between the duties that the senior IT employee undertook and the act, the dastardly deed that he did, which was to take all the employee information onto this USB stick. And that his terms and conditions were clear, that he actually had to safeguard information, and therefore the act that he did was so out with his employment duties that Morrisons could not be liable in that set of circumstances. So you can see that in both cases, it was whether there was a sufficient connection between the acts of the employee and the dastardly deed and their duties of employment. So how does this all relate to you and home working? Well, I suppose if you look at what you have set out in the employee's job descriptions, I think it needs to be very clear as to what you permit and don't permit, particularly relating to communications with clients and customers, and especially if that's being done remotely, because those conversations could be very different conversations that people are having in their flat where nobody's monitoring them and they are not being recorded, and the type of interaction that they have with their clients. And you could then have a claim against you because of rude and or foul language being used to customers or clients that you're not aware of, that you would have been aware of if this had been an office scenario. And when it comes to the protection of information, again, the individual having ready and available systems in place to protect information that could be obtained off computer systems. So it's ensuring that your job descriptions are clear as to what the job remit is and then ensuring that your dignity at work policies are clear in what you don't accept, what is unacceptable behaviour and how the individual should be treated, and providing training. And you may think that you are stating the obvious, that individuals should not swear and be rude and foul-mouthed to customers, but it's important that it is said and emphasised to employees how they should act. And that is vicarious liability.
Okay, that's great. Thanks very much, Shona. And I think we've just got a few dying moments left, and let's have a quick look. We've got only 2 questions today, which normally get a lot more than that. So if anybody has any questions, feel free to drop them in. And both relating to IR35. So Harry, I think I can probably answer both. Did you want to, because you covered this today, did you want to have a go around answering either question? Let me know which one you may want to deal with first.
Yeah, I've just checked. I'll give you my view, and Dean, do jump in, as I've just checked on the question we've had about the scope for businesses across the globe. So the question we've had from Karen is, for the exemptions, is the turnover and balance sheet amount just for the UK business if we have other businesses across the globe? And checking on this, the rules are that medium and large clients with a UK connection are within scope of the rules. So to be outside of the scope of the new rules, it's UK incorporated companies, unregistered companies, overseas companies which are required to produce accounts under the UK's Companies Act, and LLPs must fall within the definition of a small company. So it's going to depend on the particular status, I think, of the overseas company, but it seems they could fall within this if they don't meet that definition, if they are a UK required to produce accounts under the UK Companies Act, so having a UK connection. I don't know if you have any other views, Dean.
No, that's right. And once we were on the webinar as well, I think there's some guidance notes. Haven't had time to read these whilst on the webinar, but if anybody wants to look them up, I think it's HMRC's guidance notes. It's ESM 10,007, so 10007, and ESM, so there's Echo Sierra M, I don't know what the phonetic is for M, mother, 10008. I think that I believe deals with the point as well, where you've got an overseas larger company with a smaller UK subsidiary. And as you say, Harry, it looks like they don't fall within the scope of smaller companies to be exempt from the new IR35 regime. Okay, no problem, Karen, our pleasure. And just one final question in the last couple of moments. It's from an anonymous attendee who's asking, if we ask contractors to move to working under an umbrella company at the same rate they're currently working under, is there any risk to the employer? For example, could the contractor or HMRC come after us, or presumably the end user in this example, for the 13.8% employers' national insurance contributions? And did you have any thoughts on this, Harriet, or would you like me to have a go at answering it?
My thoughts were just that, obviously, if the individual is going to be employed, then the normal PAYE and NICs will have to be deducted. I'm not quite sure if I'm missing the point of the question. They'll have to be put through PAYE, so it may be that ultimately a different rate has to be agreed with the contractor to make up for that, but ultimately the correct NICs will have to be paid ultimately.
Yeah, that's right. And I think, just putting this in from my understanding as well, if this has been asked from the context of an end user, so you've got contractors or consultants working with you via personal service companies, and then you say to them, okay, we're not a small company, we are caught by the new off-payroll working regime, and we would like you all to now be engaged with us via an umbrella company, then doing so, and it would then fall upon the umbrella company to deduct pay-as-you-earn tax and also the national insurance contributions. And so they wouldn't be working via a personal service company anymore. In those circumstances, you would need to look at your contract with the individuals, or with the contractors or consultants as well, because as has rightly been pointed out in the question, the issue of employees' national insurance contributions hasn't been legislated for in the contractual relationship. So what we do recommend is, where you are asking people to make a shift to a different style of working with you, definitely consult with them. And I should add as well, what I've just said is a very, very broad-brush, very generic approach. Each case will turn on its own facts, and a specific case needs a specific solution. So if you are concerned about anything, definitely do drop us a line. We can definitely help you with this. But typically, you would want to make sure that ideally you've got indemnities in the contractual relationship as well. So maybe the umbrella company or the contractor's house, whoever you're dealing with them, will indemnify you against the fact that NICs or tax has to be deducted, and also commercially you need to address how the burden of paying the employer's NICs is going to be met as well, whether you just push that onto the contractor via the umbrella company and it comes out of their cut, or whether you'll share it or whether you'll pay it as well. So commercially, you just need to sort that out and ideally then wrap it all up in a new style of contract. So everything's very clear going forward. And that's all for me. 1 minute to foe. I think, so we've had a comment in the chat box. It doesn't appear to be a question from Samantha, but I think that's the end of the webinar now. Thank you very much for being with us. As a quick reminder, the information is accurate as of 4 o'clock today, the 8th of April 2021. We very much look forward to seeing you all. I think we're going to do it again in 2 weeks at the moment. Sadly, we won't be all in an outdoor pub at that point. I think we'll all still be working, sadly. But until then, if there's anything that you need, if you have any questions, definitely drop us a line and we'd very much like to help you. So thanks for attending and have a nice weekend and good week. Take care. Bye-bye.
Bye-bye.
Bye.
Bye.